One word I hear a lot with rules is reasonable. How do you define what's reasonable and what's not?
Well, there's no static definition to reasonable. It really varies from case to case, depending on the circumstances. Reasonable is a word that we use a lot in our profession, and so I've seen a broad range of definitions attributed to that word. But I guess to put it in an example, a lot of governing documents require that a board give an owner a reasonable amount of time to cure a violation. And so if this was a parking violation, maybe 24 hours is reasonable to allow them to cure that parking violation before they institute fines. But if they had an unapproved structure, a huge shed, and the board was asking for them to remove that from their property, I don't think 24 hours would be very reasonable. Maybe 30 days would be reasonable in that situation. So it really varies from case to case.
Would reasonable also apply what rules they create?
Yeah, well, absolutely. I think your governing documents bestow upon a board or an HOA the authority to implement rules at all. And I think even without having said that they need to be reasonable, they certainly should. So, for example, if a board was to implement some crazy rule that didn't allow folks to even park moving trucks while they're loading and unloading, I think that would be pretty unreasonable. So if a board approached me and asked me, could we implement this? Maybe they could because they have the rulemaking authority, but because it's unreasonable, a court would be very unlikely to enforce it should a dispute arise.
How can associations enforce the rules?
How can they enforce the rules? In a number of ways. And again, you're probably going to hear me say this a lot. It varies based on the governing documents. But there's typically a few options, one of which would be fines, implementing fines as a punishment for not complying with the rules and regulations. It's also to serve as a deterrent. Another one is self-help, we call. It's basically a form of if an owner's not mowing their lawn or maintaining their property and won't do so despite numerous requests from a board, they can take it upon themselves to go in, hire a contractor, maintain the property themselves, and then charge those costs to the association. We typically call that self-help. And in a lot of situations, it's not very prudent. So if, let's say, an owner puts solar panels on their house and those are not approved in the community, very rarely will a board, I never would advise a board to go in and actually remove solar panels. That can give rise to liability for the association. And also, you never know what kind of owner you're dealing with. If you go on someone's property against their will, they may come out with a shotgun on the front porch. So self-help may be an option, but it's very rarely prudent to exercise. And then obviously there's court action. So if a board has done anything and everything they can to get an owner to comply, usually a lawsuit is the last resort in which they go and seek a court's intervention and an order requiring the owner to comply with the rules and regulations.
So in South Carolina, associations, they can have punitive fines. In other states, I know they cannot.
Yeah, well, fines, I guess, when you say punitive, I think fines are always punitive. And they do allow those in South Carolina. You get the authority from your governing documents. So if an association does not have the authority in their covenants or in their bylaws, we like to see it preferably in the covenants. But if it's not anywhere in their governing documents, then they just don't have the authority and they can't bestow upon themselves that authority. It has to come from the original governing documents.
What about if an owner has an issue with a rule or a fine? Is there an appeal process for them?
Again, that would be dictated by the governing documents. And so some people have provisions that essentially say if the board deems that someone's in violation and they give them the opportunity to cure and the homeowner still does not and they ultimately fine them, sometimes some governing documents require that there be some type of informal hearing or either an appeal if you're going from a committee to a board, but it's not always required. And even where it's not required in the governing documents, I always think it's prudent for an HOA, a board, to allow an owner some type of appeal process before it escalates to last resort, a lawsuit.
When associations are creating new rules, is there a process that needs to take place? Do owners get a certain amount of time to comply? Do they have input on the rule before it becomes active?
So I'm going to speak in general terms because, again, governing documents may address this specifically, but generally we have an HOA Act that we passed here in South Carolina in 2018, and it expressly says that a new rule that's adopted is effective upon its adoption. So that means that at the moment that it's adopted, that it can be enforced. However, again, if governing documents sometimes will say that you have to give owners notice 30 days before you can enforce it. And I just think it's good practice. I think that if you're going to implement a new rule, you need to give your owners and all the members notice of the new rule and then an opportunity to comply with it to the extent that someone is already in violation. But again, I think something reasonable would be 30 days. Much more than that, I think 30 days would probably be the cap on that.